All right, ready to get started? Good. Hello, everyone. This is Emily Brummett with the Colorado Water Congress. Thank you for joining us today for our webinar on Initiative 96, Requirements for Initiated Constitutional Amendments, also known as the Raise the Bar Initiative. The Water Congress is proud to offer webinars and workshops as benefits to our members in Colorado's water community. You can learn more about the Colorado Water Congress and upcoming events at www.cowatercongress.org. I have just a couple of housekeeping notes before we begin. First off, I'd like to thank our presenters and our members. These presentations are made possible by your support. Today our presenters are Steve Leonhardt of Burns, Figa Will, Josh Penry with EIS Solutions and Raise the Bar Colorado, and Floyd Ciruli with Ciruli and Associates. We're grateful that you're all able to join us today. To learn more about our presenters, check out their bios in the handouts pane of your GoToWebinar toolbar. During today's webinar, Steve will talk about trends in natural resources initiatives, what we're seeing this year versus the last few election cycles, and what difference it makes for Colorado water law. Followed by Josh Penry, who will discuss Initiative 96 and why Raise the Bar supports it, others who support it and why, and how it will work successfully. Finally, Floyd will talk with us about the 2015-2016 political landscape and how it relates to initiatives like 96. Today's presentation will last for about 45 minutes with 15 minutes for questions at the end. As attendees, you'll be muted throughout the presentation. If you have questions during the presentation, please type them into the questions pane in your GoToWebinar toolbar, which should be on the right side of your screen. The webinar is being recorded and is available upon request, and it will also be uploaded to the Water Congress YouTube channel. If you have any technical questions, please email me at ebrummett, that's E-B-R-U-M-I-T, at cowatercongress.org. Without further ado, I'll pass it off to our first presenter, Steve Leonhardt. Steve is a shareholder with the firm of Burns, Figa Will in Greenwood Village, Colorado. His practice concentrates on water law and related litigation, appeals, and transactions. Mr. Leonhardt has represented public agencies and private parties on a variety of water matters and in hundreds of water court proceedings. He is an active member of the Colorado Water Congress and has represented the Water Congress and other clients in legal proceedings involving proposed ballot initiatives in Colorado. Steve, I'll let you take it from here.
Thank you, Emily. As Emily indicated, Josh is going to talk about Initiative 96 and raising the bar for constitutional amendment initiatives in the future. But first, I'd like to give a quick overview of what we've seen with proposed constitutional amendment initiatives affecting water over the past several years, including some trends over the past 2 or 3 years. And I think that this discussion will highlight why the water community is so concerned with how easy it is to amend the Colorado Constitution. As many of you are aware, the Colorado Constitution really provides the foundation for our water rights system in 2 provisions in Article 16. First of all, Section 5 provides that the water of natural streams that's not been appropriated is dedicated as property of the public, but dedicated to the use of the people, subject to appropriation. So the state owns the unappropriated waters, but water users can obtain rights to use water by appropriation. And the second provision, Section 6, talks about just how those water use rights work. They depend on beneficial use, and that the rights shall never be denied, and that they're based on priority of appropriation. These provisions in the Constitution have both been there ever since Colorado became a state, and this is what provides the foundation for security and stability and predictability of water rights in Colorado, subject, of course, to varying hydrology. Colorado water users have secure property rights to use the water. So that's why the Water Congress has been concerned with proposed ballot initiatives to amend the Colorado Constitution in ways that can affect water. Meanwhile, some of the initiatives have proposed a public trust doctrine in Colorado. The reason that the constitutional amendments have been needed to try to implement the public trust doctrine is that the Colorado Supreme Court has consistently rejected any public trust doctrine in Colorado, particularly a case back in 1979 called People versus Emmert that involved to what extent do people who are floating on Colorado rivers have access across private property. The Colorado Supreme Court said that these provisions of the Colorado Constitution provide water for use by the people, for not for navigation such as floating on the rivers, but for use by the people by appropriation. So the only state constitutional protection of public water is protecting the right to appropriate. And in that case, the Supreme Court rejected an argument for the creation of a public trust based on usability. The first of several cases, the most recent this year, in which the Supreme Court has noted that there's no public trust doctrine for water in Colorado, unlike some other states. So really the first proposed public trust ballot initiative that we saw was in 1994, actually, and then 1995 was a landmark decision of the Colorado Supreme Court involving another similar proposal. Many of the proposed public trust initiatives over the years were from a guy named Richard Hamilton, and in the 1995 case, he proposed an initiative requiring the state to adopt and defend a strong public trust doctrine, requiring voter approval for changes to water conservancy and conservation district boundaries, requiring election of conservancy and conservation district directors, and providing that water rights may be decreed to the public and then would need to be protected by the Water Conservation Board. The title board took a look at this initiative under Colorado's then brand new single subject requirement and said it was a single subject concerning the public's interests in state waters, but the Colorado Supreme Court disagreed, reversed the title board, the first Colorado Supreme Court decision, striking down a ballot initiative on single subject grounds, and held that the initiative really had two separate objectives, that the provisions for water conservancy district elections really didn't have anything to do with the state public trust and public water rights provisions, and therefore refused to allow this initiative to proceed. Now, the strong public trust doctrine that was proposed by Richard Hamilton and this and other initiatives is based primarily on California law, where California Supreme Court required the states to reconsider previously permitted water rights appropriations if they were in conflict with public trust uses, including navigation and fishing and ecological preservation. In 1996, Richard Hamilton came back with a similar initiative, but without the conservancy district election provisions, and the Supreme Court approved the title for that one, involving a strong public trust doctrine together with public in-stream flow water rights. Skip forward to 2007, Richard Hamilton and Phil Doe came back with Initiative 17, the main focus of which was a proposed constitutional amendment to add a new department to state government, a Department of Environmental Conservation, to include several functions dealing with water and the environment and wildlife. And in the constitutional amendment, they gave the department a mission of resolving any conflicts with economic interests in such a way as to favor public ownerships and public values. The Colorado Supreme Court, in a majority opinion by Justice Hobbs, reversed the title board setting of the title for this initiative, found that it violated the single subject requirement because it not only created a new department in state government, but also set a new substantive standard, a public trust standard for agency decision-making, similar to the public trust standard proposed in some of Richard Hamilton's previous initiatives. 2012 is when the Water Congress and water community really took note that we've got a trend going here. There were two initiatives in 2012, both dealing with the public trust, specifically with regard to water. Initiative 3 proposed to adopt a Colorado public trust doctrine and amending the constitutional provision on unappropriated water being property of the public and making it public property for purposes other than appropriation. Basically overturning the Emmert decision, granting access to waters, as well as creating a public estate in water with legal authority superior to contracts or property law or to previously decreed rights. The Supreme Court majority upheld the title set by the board for this initiative, with a vigorous dissent from Justice Hobbs, who characterized this as dropping a nuclear bomb on Colorado water rights. The proponents of the initiative did go out and gather signatures, but they failed to collect a sufficient number of signatures and ultimately threw in the towel a few months before the election. Initiative 45 was by the same people at the same time, Richard Hamilton and Phil Doe. This was an amendment to basically an amendment to Section 6 of the Constitution on the right to appropriate, and extending that right from waters of natural streams to any water in the state, so it would have included non-tributary groundwater, but at the same time providing for the state to limit or curtail diversions in such a way to protect the natural elements of the public's dominant water estate. So this would have amended and taken away the provision in the Constitution that rights to appropriate water shall never be denied. Finally, Initiative 45 had a requirement to return water unimpaired to the public after use in order to protect the environment and public uses. The title board had a split decision with a 2-to-1 majority, finding it was a single subject setting title. Supreme Court also had a split decision affirming that result with another dissent by Justice Hobbs, who pointed out the extent to which this amendment could deprive Colorado of the water that's apportioned to it by interstate compacts. The proponents were gathering signatures at the same time on Initiative 3 and 45, and ultimately did not get sufficient signatures on either one. In the last few years, we've seen much broader initiatives trying to take on the subject of public trust and environmental rights and local control versus state control. A lot of this activity has been focused on the oil and gas industry in particular, but some of the proposed amendments have been much broader than just oil and gas, and creating kind of a universal public trust in natural resources and the environment. Phil Doe from some of the other recent initiatives returned in 2014 with Initiative 103, proposed amendment to the Colorado Constitution, adding a new section to Section 16, establishing an inalienable right to clean air, clean water, preservation of the environment and natural resources, all of which were characterized as public trust resources, designating the state as trustee of those resources and requiring the state to conserve and maintain the resources for the benefit of the people, and basically providing that this amendment would apply to all public actions or commercial transactions that could violate the provisions of the amendment, regardless of when any previous permits may have been granted. So this initiative would have been retroactive to any previously granted permits, such as water rights. The Supreme Court overturned the title that was set for this initiative on procedural grounds because somebody had failed to show up for one of the required hearings. So Phil Doe promptly came back by the end of 2014 with an initiative for the 2016 ballot, Initiative 4, virtually identical to Initiative 103. And in this case, the title was upheld by the Colorado Supreme Court. However, that title expired several months ago because Mr. Doe did not collect or submit the required signatures. So this is one initiative we've seen with a broader form of a public trust doctrine based on environmental rights, similar to some environmental rights amendments adopted in the 1970s by a few other states, such as Pennsylvania and Hawaii. So local control is the other theme that we've seen recently, and the main current example of that is Initiative 40, which we discussed in a webinar here last month, and hopefully some of you were able to hear that information. This is one that's currently circulating for signatures, would add a new section to the Bill of Rights in the Colorado Constitution, creating an inalienable right of local community self-government for each county and each municipality, including the power to enact laws protecting health, safety, and welfare, and recognizing and establishing rights of natural persons, their local communities, and rights of nature. Those local laws would then control over any less restrictive conflicting state laws. The Supreme Court affirmed the title for this a few months ago, and proponents have been trying to collect signatures. This is really the strongest and the broadest of several ballot initiatives we've seen in the last couple of years. on the theme of local control with giving local governments increased authority to override state preemption of local laws. Most of the others have had the narrower focus on oil and gas development. But in 2014, we also saw Initiative 89, which combines all three themes of public trust and environmental rights and local control by adding a new section to Colorado's Bill of Rights, declaring the environment as the common property of all Coloradans, declaring that conservation of the environment is a fundamental right, and that state and local governments are trustees over the environment, so establishing a public trust with multiple trustees, and then having a similar local control provision that if a local law conflicts with state law, then the more restrictive and protective law would govern. In 2014, the Colorado Supreme Court upheld the title setting for Initiative 89, a dissent from Justice Hobbs joined by the Chief Justice, and the proponents led by Congressman Jared Polis then filed signatures for the initiative in August of 2014, but then promptly withdrew the signatures based on some discussions between Congressman Polis and the governor. Last but not least, this year we've seen Initiative 63 that deals with both environmental rights and local control, but without the public trust component to it. So the public trust and common property provisions of Initiative 89 were basically surgically removed from Initiative 63. So Initiative 63 would recognize a new fundamental constitutional right to a healthy environment, declaring that state and local governments shall assign the highest priority to protecting a healthy environment, and again providing for local preemption power similar to some of the other initiatives. The Colorado Supreme Court affirmed the title for this initiative just last month with a dissent from Justice Gabriel arguing that the requirement to assign the highest priority was in fact a separate subject. So Initiative 63 has been cleared for signature collections. It's unclear whether the proponents are actually pursuing signatures on this one. The same proponents are also proceeding with Initiative 75 regarding local control specific to oil and gas development, and Initiative 78 regarding setbacks for oil and gas development. And the proponents have been more vocal about their efforts on those two initiatives than they have on Initiative 63. So last but not least, let me just raise the rhetorical question whether Colorado's Constitution is too easy to amend, and is there a solution out there to the problem that may exist? And there will be an opportunity for questions and answers following presentations from Josh and from Floyd Ciruli. And here's Josh to talk about Raise the Bar and Initiative 96.
Great. Thank you very much to the Water Congress and its team, and to you for the excellent presentation. It's great to be back at the Water Congress, although the room is much emptier, which makes this the easiest audience I've ever been in front of in the Colorado Water Congress. But look forward to a conversation with you about this, in exchange for hearing from Floyd as well. It's a real pleasure to be associated with this initiative, Raise the Bar, an effort to safeguard Colorado's Constitution, make it more difficult to amend the Constitution. The excellent presentation you just heard, I think, is emblematic of what the state is up against on an array of issues, whether it's the business environment, whether it's core rights or values, whether it's fundamental property rights. So long as our system makes it, creates a playing field where it's exactly the same to change statute or the Constitution, the people of this state are one election cycle and one slogan and a couple of $1 million away from having wholesale changes in ways that will adversely affect the rights of citizens. Colorado is unique. We make it very easy to amend the statutes through the initiative process. That's a good thing. But by setting the bar exactly the same to change the Constitution and state statute through the initiative process, what you do is you create an incentive for those who want to change the law. Just if you're going to go to the trouble, you might as well put it in the Constitution. The problem with that, of course, is what's in the Constitution as a practical matter, it's there forever. It's very difficult to unwind and change. And so this is a great proposal. It's one that is engendering broad bipartisan support. I'm eager to describe a little bit more about it. If you look at the Constitution compared to the federal Constitution, Colorado has more than 150 amendments. The U.S. Constitution only has 27. And that only begins to describe the situation, and the whole water conversation is definitely pertinent. This state spends more time, more energy, sort of more political will fighting off bad ideas probably than any other state in the union other than California. Every 2 years, a number of bad ideas that would fundamentally change the state come along, and they may or may not sound good on bumper stickers, and they may or may not have significant resources behind them. And the state's leaders are forced to rally and find a way to defeat them. I see this next slide demonstrates how Colorado stacks up in terms of the number of proposed constitutional amendments. We're essentially third behind Oregon and California. And closing quickly, this year there was, I think, nearly 100 proposed constitutional amendments that were filed, and a number of them are actually still pending. I'll talk some more about that here in a moment. This slide also visually demonstrates the trajectory of use of constitutional amendment in the ballot process. It's a vertical climb. This only goes to 2010. In the last 5 or 6 years, and certainly this year, as I just described, this line goes vertical. There are more and more constitutional amendments being proposed every year. Again, all things being equal, if you're going to go to the trouble of collecting the signatures and the rules are just the same, why not put it in the Constitution? That's what interest groups are doing. So this plan, raise the bar. So the plan didn't come from nowhere. This has been a conversation that those of you in the water community know well. That's people who follow the political process in the state. This is something that's been discussed for a very long time. About 18 months ago, Dan Ritchie, the former president of University of Denver and sort of emeritus leader in the state, brought together Republicans and Democrats to talk about a range of issues affecting the state. And 3 specific issues, 3 specific proposals came forward. All 3 of those are going forward to the ballot. The 3 issues have separate campaigns, separate coalitions. They're very separate, but they all came from the same starting place, which really was a broad-based bipartisan conversation of about how the state moves forward. This proposal is the end product and the raise the bar requirement. Currently, to put a measure on the ballot, whether it's on statute or the Constitution, you have to simply collect a 5% of signatures from that were cast in the Secretary of State's election from the previous cycle. 5% requirement. There is no regional or geographic requirement. As a practical matter, that means that signature collectors and proponents of initiatives can come to the large metropolitan areas, collect their number, and they are on the ballot. Our process would change that. We don't change the total number of signatures required. The total number of signatures required today would be the same, or in the future, prospectively, would be the same as today, but we do impose a new geographic requirement that is one that actually many other states, an approach that other states have used. Essentially, it says that, okay, you have to collect 5% of the signatures, but within that 5% framework, you have to collect 2% of the registered voters in each state Senate district. So of that 98,000 some odd signatures on a statewide basis, you have to collect, the numbers vary from Senate district to Senate district, between 1,200 and 2,000 signatures in each state Senate district before your proposed constitutional amendment can be qualified. It says a number of things. First of all, it strips away the status quo where you can just come to the large urban areas or a handful of areas and not engage the broader public in a conversation about their rights, about their Constitution. It'll also force, I think, a vetting process. If you have to go out into these communities and collect signatures, you're going to have a conversation, and that's going to invite questioning, and it's going to invite give and take and a more informed electorate. But ultimately, proponents of initiatives aren't just going to be able to sort of, constitutional amendments aren't going to just sort of be able to pay their way onto the ballot. It's going to force a broader civic conversation. So that's the first requirement. We change the signature requirement to require signature collection in all 35 state Senate districts. And the second requirement is one that is important. Requires that for a proposed constitutional amendment that's put on that makes it on the ballot, you have to get 55% of the vote instead of 50% plus 1. For reasons that are intuitive. You hear it in the conversation about these proposed initiatives relative to water in the past. Essentially, these proposals are an attempt by interest groups for a majority, 50% plus 1, to enact measures that would take or strip away the rights of minority populations, of something less than the majority of the citizens, just by a simple majority. our U.S. Constitution, if you go back to the Federalist Papers, lots of discussion about why there should be a hierarchy of laws and there should be a Constitution that protects core rights. And what we're saying with this is, okay, if you're angry at the governor or you're angry at the legislature and you want to change in the statute and you want to change policy, you want to change laws, you want to make policy changes, do that and do it by the same rules as today. But if you want to change sort of the fundamental document that governs the state, or bedrock principles that protect core rights and core values, you have to get 55% of the vote. As I said, so looking at this on a signature requirement basis, currently you can essentially, go and get all the signatures in one area. Some people said, why not do it by congressional district? There are 7 congressional districts. That would be an easier standard. So why 35 state Senate districts? If you look at the map, this is 35 state Senate districts. If you only had a congressional district requirement, essentially you could stay on the I-25 corridor from Greeley to Pueblo and meet the signature requirement. And so there really was a desire on the part of the Building a Better Colorado, the thousands of people that were part of it, to force a statewide conversation before the constitutional amendment could be amended. And so you're going to have to go into, look at the corners of the state will, for the first time, have a more meaningful role in what actually makes its way to the ballot. And this is really important to rural Colorado. I know rural Colorado is well represented in the Colorado Water Congress. And some of the leading voices in rural Colorado, Press 15, Action 22, Club 20, have spoken out strongly in defense of this new signature collection requirement. And editorial voices, the Durango Herald, the Daily Sentinel, just 2 of the rural voices who have come out strongly in favor of the measure in general, but specifically this requirement that the whole state is engaged. On the 55% requirement, the start of the conversation is look at the United States Constitution. In order to change the U.S. Constitution, 2/3 vote of the House, 3/4 of the state. It's not an apples-to-apples conversation, but our Constitution, our U.S. Constitution, has done pretty well for us through the years, and the understatement of the day. And our founding fathers and framers wanted to create a construct where it could not be willy-nilly changed easily, and they set the bar, they set the bar high for that reason. If you look comparing apples to apples, Colorado to other states, our constitutional amendment process is far easier than all the in its totality the other states by a number of measures. Colorado is of the 15 of the 18 states that have the initiative process. They require 8% or more of signatures of the overall voting population. And a large number of those, as was noted before, a near majority of those require a geographic requirement. So again, if you compare Colorado to the other states, we require fewer signatures and we have no requirement, unlike many other states, that a geographic threshold is met. There's also small things, how we benchmark our signature requirement. We benchmark, we say 5%, actually I said 5%, 6% of the vote, but we don't benchmark it to a presidential vote, which is sort of the largest possible segment. We benchmark it to a down ticket race, a Secretary of State's race, which means that 6% of a smaller universe of voters. Another subtle but significant way in which our bar is lower than other states, and as I said, 8 states also have some type of geographic requirement. On the 55% issues, a number of states approach these issues different ways. Florida, for example, requires 60% of the vote. A couple of states require that in order to change the Constitution, only requires 50% plus 1, but you have to pass that measure in successive elections. Again, another check on the process, a different way of getting towards the same end, which is making the Constitution more difficult to amend. This is not the first effort like this. In 2008, a historic election, there was a down ticket question, referendum no. I supported the measure in the legislature. It was different. For example, the requirement on passage was 60%, not 55%. There were some shades of gray difference, but sort of the impetus was the same. That measure narrowly failed, but it wasn't a particularly well-funded campaign in a cycle where there was tremendous clutter, focus on other issues. A lot of activities going on. That will be our challenge as a campaign, certainly this go around as well. But I think we take heart in referendum O. Interesting side note on referendum O: who should support this measure geographically more than others? Rural Colorado should. In our poll polling shows that this thing has big support in rural Colorado, which we'll see in a second. Referendum O actually failed across rural Colorado, I think simply because they didn't have the resources to drive a message. And this is, this is like I described as teaching a civics lesson amid a, amid a general election, which is not easy to do in a competitive state like Colorado. So, the critics of this say that this is tried and failed. The truth of the matter is, I think many of us take heart in referendum O, and we're working to learn lessons from it. And we think the passage that referendum O portends good things for us in the fall. Key points: nothing in this proposal removes the right of citizens to effect change through their initiative process. We've seen this; it's very disingenuous from some of the critics. They want to take away the citizens' right to vote. This is all about special interest groups. This is a bunch of nonsense. The truth of the matter is, if you are angry, as I said, at the governor or the legislature, or there is a law or a policy that you don't like, you can change that law or change that policy in the same way. Indeed, if you want to change the Constitution, we are not taking away that right. What we're saying, though, is that if you want to make it forever or near forever and put it in the Constitution, the standard should be higher. The nature of our support is it's broad and bipartisan. I won't bore you with names. There is an important, I think that in a time of tremendous division and acrimony in our politics, the fact that both sides are coming together around an issue for different sets of reasons like this, I think, speaks in a positive way. A number of folks that I've served with in the legislature, Republicans and Democrats are for it. Governor Owens, Governor Lamb, Governor Romer, Governor Ritter, Governor Hickenlooper are all supportive of it as well. A little bit about our polling. I think I'm running out of time. 60% of the in our initial polling support it, which is a good. Floyd can talk more about this. He's an expert in public opinion. 60% is a good place to start. It's not a slam dunk, but it is a solid foundation on which to wage a campaign. An interesting sidebar: one of the challenges in these ballot initiatives, there are a lot of challenges. It's always harder to get the yes than the no, and we tested a lot of language approaches. And one of the things that we saw was it's complicated. Again, this is a constitutional amendment to make it more difficult to amend the Constitution. And so we knew it was very important for us to get the words in that first sentence, making it more difficult to amend the Constitution. All of our polling showed that the people fundamentally internalizing get that concept. And we knew if we could get that language through the various processes and ultimately the Supreme Court, that we'd give ourselves a much better chance of passing, and that language was approved by the Colorado Supreme Court. So a lot of work went into this language. I don't know that the water lawyers in the crowd will appreciate making something simpler than it needs to be, but we think it ultimately gives us a good chance to win passage. This has big support across the state. Republicans, Democrats, and Independents is a strong starting point on which to make the case, and then broad geographic support as well. A final point in closing, that I think is where it's definitely pertinent to this. I brought Floyd onto the screen, so good. Welcome, Floyd. The opportunity cost of the status quo. If you think back, about every 2 to 4 years, we have these crises, and they almost always revolve around proposed constitutional amendments. In Governor Ritter's first year, there was a big fight in the state capitol over labor issues, for example. Many people remember, and a group of conservatives and business leaders pulled a right-to-work initiative that the unions hated, who themselves put forward 4 or 5 horrible proposals intended to be punitive towards the business community. And they were proposed constitutional amendments. There was a big fight about what would be done and how would it all play out. Time, energy, resources, months of public attention focused on that, and ultimately it went by the wayside. But again, at the cost of a lot of political capital and focus. A few years back, we had a huge tax increase proposal, 60, 61, and 101, proposed by my friends at the Independence Institute, which was so ridiculous and so absurd that many tax-cutting conservatives like my thought said, "What are you doing? This is a terrible idea." It would have defunded water infrastructure, transportation, a whole range of things. The business community, again, because it was a constitutional amendment and there was no way to fix it if it had been enacted, was forced to spend millions and millions of dollars, a waste of time, energy, and resources fighting these things off. This year, there are proposals to create a put minimum wage and an automatic escalator into the state constitution. Minimum wage is an important policy. Do we want it in the Constitution with a permanent escalator? We have a proposal for single-payer health care in the Constitution. Setbacks, and all these things proposed for the Constitution, and they all speak to our systemic the flaws in the system now, which is if you want big change and you have an open checkbook, all things being equal, why not put it in the Constitution? And that is a fundamental reality that we're trying to reverse, again, not by making it possible to amend the Constitution, but by making it more difficult to do so. So I think I won over somebody's dog along the way, so I guess that's a good point. We should say thank you.
So now we're joined by Floyd Ciruli from the sunny beaches of California. Floyd, we're very grateful that you could remotely join the webinar today. So I will pass it off to you. And if we could have Steve or Josh advance the slides for Floyd, that would be great.
Thank you, Emily. Can you hear me okay?
We can.
Steve and Josh did a great job of framing this issue. As I think many people on this webinar know, the Water Congress and the Stewardship Project, of which this is a part of, I have been concerned about this for 3 years now, starting in some of those initiatives that Steve was describing back in 2012 and 2014. And so that, and of course, we had a webinar approximately a month ago on one of the initiatives, Initiative 40. So this is an ongoing concern, and I think that the process that Josh described is that a group of local government, business, and statewide civic leaders have come together for probably about the first of the year or so, maybe a little before that, and talked about some of these options, and this one was one of them they came up with, and that is dealing with the fact that we had maybe 170 initiatives filed this year. We had 145 filed in 2014. So this is a serious topic that we've been having now for some time as to whether or not should we make some adjustment related to the our constitutional ability to change through our direct democracy provisions. This is an interesting election cycle. We're expecting maybe more than 3 million voters, but we're not at all certain about that. If you put these voters on a continuum from right to left in the Democratic Party, the younger voters who are more liberal, we're not certain how many are going to turn out vis-a-vis the fact that the likely nominee is going to be Hillary Clinton, who they did not favor, including in the Colorado caucuses. On the center right, we have moderate Republicans. Will they turn out, given that Donald Trump is still in some disagreement with a number of them? Will the further right turn out, strong conservatives, because Trump is, in point of fact, again, the presumptive nominee, not in alignment with many of their issues. And so as we look at the turnout factors in November, there is a lot of volatility, and there's a lot of unknowables in terms of what's going to happen in this election environment. But one thing that we do know about this environment is that one initiative is already on, and that is single payer. And as Josh and Steve described, this is one of these initiatives that is truly dramatic. The minimum financial impact of it, which is in the ballot language, is $25 billion. But many people, including some advocates, have stated that it will be much higher than that. It will be well over $30 billion. Advocates argue that, well, it will be an exchange, that you will have to not pay for health care through the system that you're currently using, the insurance system, and it'll absorb a number of other government systems. But nonetheless, that is the potential impact. It will be as dramatic to the healthcare system as, let's say, Tabor was to the local government finance system and to the state government finance system, and to a number of other initiatives that have been recently proposed in terms of how they would change major elements of the government or major elements of our economy. A recent survey that I conducted here in the metropolitan area indicated that a very significant number of people do not know exactly how they would vote on it at this time. The support was about 30%, about 43% were against it, and everybody else was undecided. As you can see, Republicans in the slide were early on opposed to it, although there are some Republicans who see it as a way to remove Obamacare, which they're also not in favor of. Democrats were somewhat more in favor of it, and as usual, unaffiliated voters were sort of in the middle. But the point is that a very, very dramatic change to our healthcare finance system potentially is on the ballot. It will be voted on. Something that comes out of it and also corresponds to other initiatives that Steve talked about, and that is that the language, ballot language, is by and large designed to be almost a marketing device. And that while Steve pointed out that several challenges to single payer, or pardon me, single subject rule have been upheld and initiatives not allowed on ballot, by and large there is a presumption, and there has been a sort of a Supreme Court position that has been very, very generous to initiatives that are, to say the least, not fully descriptive of what would possibly happen. So when you look at the next slide related to the gas and oil initiatives, many of them, whether they're talking about local control or environmental quality, will, in point of fact, as Steve described, have dramatic, or potentially dramatic impact in terms of litigation, in terms of changing economic relationships, in terms of changing the ownership of water, investments that have been made in water, planning that's going on right now related to major projects concerning water. None of those would necessarily be discussed. They're certainly not mentioned in the ballot items. One of the things that's that I'm often asked about, this was a major issue in 2014. It consumed most of our summer's discussion, whether or not there might be a special session. Our governor and one of our Congress people, Jared Polis, who was mentioned before, were highly engaged in it. And ultimately a decision, a compromise was made in September, and they were pulled from the ballot. But are we in the same situation this year with the initiatives that are in the circulation, signature circulation process right now? And I have argued that, frankly, it's a little different this year. Our gas and oil industry, as when you look at Weld County, for example, and the layoffs and contractions that have taken place, it's a little less intense than it was, obviously, in 2014, simply because of the price of gas and oil. The concerns in many of our municipalities along the Front Range, particularly Fort Collins and Longmont, appear to be somewhat less intense than they were. One thing you would say is the gas and oil industry, along with their allies in the economic community, have really dramatically stepped up their activities in terms of communicating to the public in general, to let people know that from their point of view there's a lot of benefit from the gas and oil industry. Also, you don't see the infusion of very significant money. That's not to say, as single-payer healthcare pointed out, that you can get onto the ballot here pretty quickly with some passion and a little bit of money. But nonetheless, you don't see anywhere near the millions of dollars that were potentially going to be invested, and to some extent were invested in 2014. And finally, there's some polls out there that indicate that while there is still lots of, obviously, support for the environment, particularly among Coloradans, it's a little less intense than it was before, partially because of some decisions that were made related to the pipeline from Canada, and also that we've resolved or addressed some issues related to air pollution and water pollution, which have sort of tamp down some concerns. So whether or not they will make the ballot, many of these initiatives that are really aimed at gas and oil, or whether or not they are going to, would they be successful once they make the ballot, I would suggest they have a little more difficult year. But I think the point is that every one of them, as described, could be revolutionary change. Local government, for example, would dramatically change our constitutional arrangements in this state, and that is that local government will, having significant power through home rule statutes, nonetheless has some limitations, and we understand what those limitations are. This would be direct democracy on steroids at the localest possible level, and with a lot of implications that we would not know about until they were implemented. So I will end with that background in that this is a very volatile year. This is a year in which we are uncertain as to exactly where we're going to end up. We won't know until later in August as to how many of these initiatives may make the ballot. But with single payer alone, we will have one major decision to make that will have huge implications for not just the healthcare community, but for businesses across this state in terms of what they will pay for healthcare and what citizens will pay for taxes, what retired people will pay. So it will be very, very significant, an example of what this ballot initiative, what we're talking about here, and how important it is that we address whether or not we want to proceed forward with Amendment 96. Obviously, they're having to make the ballot. And with that, let me stop. We'll go to questions. A few of them have been already submitted, but why don't we just open up and see, Emily, if there's some questions from the audience, and then if not something immediate, I have a couple that I would be interested in asking.
Perfect. We have one question. This question is for Josh, and it comes from Chris Piper. He says, will raise the bar apply retroactively to previous amendments to the Constitution?
Thanks for the question, and hi, Chris. Hope you're well, buddy. So it's a good question and an important provision in it. So the way the raise the bar amendment works is it essentially applies prospectively to constitutional amendments. So new amendments that are offered to the Constitution would have to file to meet the 2% geographic requirement and the 55% requirement. If you wanted to go back and repeal or modify existing provisions of the Constitution, the 55% requirement would not control. Part of that is a pragmatic approach and a fairness approach. The pragmatic approach is if you go down that road, you open cans of worms that create coalition and just basic political questions that make it more challenging to sell. But no, there's also a fairness question. The rules were the rules when the Constitution was created, and if somebody wants to go back and change the rules, then the same rules should apply. What would apply though to proposed constitutional amendments? The 55% requirement wouldn't, but the 2% signature requirement would in fact would be in place. So that's also consistent with what happened in referendum O as well, and we think it's one that it was vetted through that process, and then it gets to the Building Better Colorado process. You know, the consensus was apply this prospectively in general to new amendments and treat those that are in the Constitution the same way.
Great, thank you. At this time, we currently don't have any more questions. If you do have a question, there is a questions tab on your GoToWebinar toolbar, and you can just type them in there and I will read them aloud. So in the meantime, let's get back to Floyd. I think he said he had a couple of questions.
Yes, also to Josh, and that is that when you look at that graph of yours that Colorado was third, let's assume we adopt these changes, the 55% rule and the geographic rule, the 35 Senate seats. Where would we move in that scale? Would we be toward the middle, or would we be toward the far end in terms of difficulty? Any sense as to where we would now be positioned if we adopted?
A really good question. So in the status quo, we are clearly the easiest. We're the easiest constitution to amend in the country by orders of magnitude, both on the ballot qualification piece and then on ultimately the final passage. If you project forward and if this is enacted, we kind of fall somewhere in the middle. On the enactment piece, as I said, the Florida requirement is 60%, which is, you think about how divided the state is. Barack Obama won a sweeping victory in Colorado in 2012. What was his margin? 5 or 6 points. To get to 60% is a super high bar, and that's Florida's bar. As I said, other states require you to pass it in successive elections. Massachusetts has an indirect process where if you want to amend the Constitution, the legislature gets a bite at the apple first. None of those required, all of those requirements, I should say, constitute a higher threshold than Colorado would, even under the raise the bar requirement. And the other states, as I said earlier, require, 15 of the 18 require 8% of the voter base. Some off of a presidential base, so it's a big number of signatures, will only require 5%. Still, there would just be a geographic requirement. Our geographic requirement will be among the more meaningful ones, although states like a number of states required by congressional district. Arkansas, by way of example, requires that you collect between 5 and 10% in at least 15 counties. So again, is ours more difficult than that? Probably not. So to answer your question in general, if this is passed, Colorado still has arguably the easiest process to change statute, and our process to amend the Constitution will fall somewhere in the middle of the continuum of other states.
Thank you. I think that was the I sort of assumed that would be the answer, and I think that at least some people are, 55% is a quote a violation of a general one vote, one person majority rule. Now, as you pointed out, to change the Constitution of the United States, it's much more difficult than even that. 2/3 and 3/4 of the states. There's also, as you know, a lot of supermajority rules in the operation of the Senate, in its normal operation because of the filibuster rule, but even beyond that in terms of treaties and other things. So I don't know if that is an argument, that how impressive that argument is going to be, but I do think being able to say that this would still allow access. I mean, one of the other things, I don't know if you thought about this, Josh, or had to answer that question. You sort of explained why not go to a congressional map, and I think that sort of made sense. That is that you would not be, people would not necessarily have to get out to the four corners, so to speak, out to the west and east slopes. But on the other hand, how difficult is it? We saw how difficult it is for the Senate candidates most recently to get signatures in 7 congressional seats. Just from your sense, how difficult will it be to get some signatures in 35 Senate seats?
It is a meaningful requirement, as I said, in actual numerical terms, between 1,400 and 2,000 signatures, but it is by no stretch of the imagination impossible or anywhere near it. If you look at the way redistricting, when these districts are drawn, they have to be essentially comparable in size. So what that means as a practical matter is the geography frequently changes, but there are always population centers in a district in order to get to the magic number. There are a handful of districts, 6 to 8, that are definitely more rural in their character, but even those have population centers. You look at the southeast Colorado, you have a huge chunk of Pueblo. You look at the southwestern part of the state, you have Montrose, and you have Durango, and you have Cortez, themselves population centers where there's tens of thousands of people who live in these communities. So when you compare that to a signature requirement of 1,400 to 2,000, it's the right balance. We feel good about that balance. It's a very defensible balance. Notably, in our polling, with as a side note, this piece, the signature collection requirement on a statewide basis, is hugely popular. It's just basic fairness. The Constitution applies to the whole state. You should engage the entire state. The 55% question is an interesting one, and I think if you talk to some of the proponents of referendum O, they would probably say that REFO failed and they lost support among key coalitions because 60% was just a bridge too far. And this is, you know, a sort of a lessons learned phenomenon. You know, on the one issue, one vote thing, it's important to remember that Colorado, as I mentioned in the slide, there's 18 states that have a form of direct democracy. Many states don't need this venue, this mechanism to change statute or the Constitution via the initiative process doesn't even exist at all. And so we're not it's rooted in who we are, that process is. What we've tried to do is create a balance that makes it more difficult to amend the Constitution. And as a byproduct, it eliminates this incentive to put, you know, fanciful notions or public policy changes into the Constitution where they're likely to be forever, instead of putting them into the statute where there's more flexibility for, you know, for their treatment over time.
Thanks, Josh. So I have two more questions from the audience. The first comes to you from Tad Foster. His question is, if Initiative 96 passes, does this lock in Tabor and make its refinement unattainable?
The answer is no. It's a question that we get a lot, and the answer is no. As I said in answer to Chris's question, if you know, the existing provisions that are in the Constitution, if you wanted to go back and change them, then the old rules of passage, 50% plus one, is what would control. There are some who are focused on marijuana. There are some who are focused on Tabor. There are small business leaders who are focused on Gallagher. And rather than, as a pragmatic consideration, open all of those fights and essentially make it harder to take out of the Constitution than they were to put in, we sort of held them harmless, and they kind of gore both sides' oxes. And at some point, we may have debates about those, but they could be changed by the same rules. And we think that's the right approach, because, you know, if you're going to change the rules in the middle of the game, then you shouldn't, I guess, is the way to say it.
Great, thanks. One more question. It's also from Chris Piper. What previous amendments, if you know, would not have passed under a simple 55% rule?
That's a good. There, I actually have another slide that I use frequently, and maybe what I'll do is just send it to you to circulate around. I mean, one of the for my friends and critics of the measure on the right points, term limits is one example that's popped up that received less than 55% of the vote. And my rebuttal to that always is, it's enactment. If you look at the polling on term limits now, it is in the near 80%. There's broad support for term limits. So would term limits have passed that year? Actually, maybe or maybe not, right? Maybe the proponents get more resources because they know they have to get over the 55% margin and wage a campaign differently to get to that magic number. But most of the yeah, that's the one that gets a lot of the attention. But I'll send it to you. There's an interesting slide. To me, though, that is it's hard to get. It's a static analysis, right? Because when the rules are the rules, people spend more or campaign more and differently based on what the rules are at that time.
Okay, so I'll make sure to send that slide out to everyone. Floyd, do you have any more questions?
No, that was my last question. I know there's everybody will have a favorite amendment that they feel would have not passed. I hear from some folks that marijuana, I think, came in at less than 55%. But I guess as Chris pointed out, or as Josh pointed out, when you know the rules, you change your behavior and your campaign modes. Although on the other hand, you know, you look at some of these initiatives that wouldn't have passed, and you, I think some part of the audience out there would breathe a sigh of relief. They would say, well, gee, there's good news. But so everybody has a different perspective. But I think if we set this rule, and I think 60%, as Josh pointed out, is a solid place to start. Obviously, there will be a lot of dialogue on this. I have no doubt it will make every editorial page in the state take a position, and whether the parties do or whether a lot of politicians get involved. Obviously, some have already signed on, particularly some of the senior establishment politicians from the last many years. But it's going to be, I think this will be one of the highest profile issues out there. So I'm glad we had a chance to present it, and we thank Josh and Steve for this.
Can I just make one comment? The calculus does on this question of how would previous measures, how would it have played out? I mean, it is an interesting question, and if you do game theory and project forward, what does it do? If you have a policy and you're polling in the low to mid 50s or even in the high 60s even, or if you have a popular idea, it forces you to make a choice. Does this really need to be in the Constitution? If it does, it's just going to be a little bit harder. And so as you look in the rearview mirror, so what might have happened, what probably would have happened, would have been a decision to put things in statute versus the Constitution. A great example is Amendment 41, Jerry Polis's first foray into initiative politics, dealing with ethics in government in the wake of many scandals in Washington, D.C., a broadly popular idea that turned out to have a whole lot of just kind of implementation, legal, accidental, unintended consequences. But because he locked them in the Constitution, you had questions of whether or not, under the umbrella of a law dealing with ethics in government, a firefighter's son could receive scholarships from private charities because that was a gift to a government official in excess of the authorized amount in the measure. And so, as you look back, the key point to think is this doesn't, all these things that have been put in the Constitution, all of them, they would have forced a decision on the proponents. Does it really need to be in the Constitution? And if the answer is yes, then it's worth the extra effort. If not, then take it to statute. I would actually be interested in both of your opinions on the likelihood on the water issue, right? I mean, it's important, obviously, but as important as it is, it's also complicated. And over time, I mean, you've looked at the history. Over time, is something like this likely to actually make its way, onto the ballot? And is it difficult to defeat if it were to make it onto the ballot?
Yeah, well, let me just say some of the proposals we've had over the years have been fairly complicated. Some have been really facially very simplistic, such as this fundamental right to a healthy environment. And Floyd is the expert on public opinion. I'm just curious what you think in terms of how those would go over and what's likely to influence the debate one way or the other.
We're about to test those terms in a statewide survey, but as I sort of described, ballot issues are designed as sort of marketing tools, and often are deceptively appealing and much simpler than the implications that would be that will ultimately flow from the initiatives. And my sense is that both local government and quality of life are terms that we value in this state, and so at least initially, I think there would be a presumption that they would be popular if you were just starting to read that ballot issue with no further context or background in a polling question.
Great, thanks, Floyd. We've run a few minutes over, but we have one more question, so I'd like to take the time to answer that. The question comes from Rachel Zatterstorm. It's a clarifying question. So in order to repeal previous constitutional amendments, it would still require 2% of signatures from each 35 Senate districts?
Correct.
Yes?
Yes.
Okay. Okay. So I think that's all we have time for today. I want to thank our presenters, Steve, Josh, and Floyd. And this webinar was sponsored by the Colorado Stewardship Project. So we appreciate everyone who has contributed to the project, and it goes to sponsor events like these. So thank you very much. This webinar is being recorded, and it will be available to you upon request. It also will be posted to our YouTube channel. I'll send that link out to our attendees once it is uploaded. And with that, I think it's time to go. So thank you very much, and have a great day.
Thanks. Enjoyed it. Yeah, it's great.